All right, welcome to another edition of Ask Anthony Live. Thank you for joining us today. Remember, if you have a problem you just can't solve, you can always email me at askanthony@firstcoastnews.com. And lately, I have been receiving a lot of emails, phone calls, text messages from many of you with issues that you're having. And as the segment is called Ask Anthony, I'm just one person. So I'm trying to answer as many of your questions as I possibly can. So we want to spend some time today and answer some of the emails that I've received lately, some of the problems that many of you are having out there. I'm sure that there might be someone else that can relate to the same issues. So I want to bring in a friend of our segment, that is Adam Thoresen with Jack's Legal Aid. He is returning today to answer some of your questions and just kind of offer some advice for some of your situations. Adam, thank you so much for being here with us. Once again, just kind of let people know who you are.
Sure. Yeah. First of all, thanks for having me back. Had a great time last time, and hopefully I can help take some of those emails answering off of your plate and chip in here a little bit. So I'm an attorney here in Jacksonville. I've been practicing since 2008. I'm with Jacksonville Area Legal Aid. So we are a nonprofit law firm. We're downtown on Adams Street. That's where our main office is. And we primarily represent low-income folks, seniors, veterans, people with disabilities. So if you have a legal issue and you think maybe you can't afford a lawyer, contact Jack's Legal Aid and maybe we can help out.
An excellent service. All right, Adam, thank you. We want to go ahead and start answering some of the emails that I've received. And these are some emails that I have received in my inbox fairly recently, probably in the past week or two. I've received some emails from many of you about the different issues that you're having. I want to start with Alexis. If our producer Andy could pull up that question. This is what Alexis emailed me. March 29th, I went to a Jacksonville hotel and let valet park my car, and it was scratched up pretty bad from a valet driver running over a curb. I tried going through corporate and management, but nothing was done, and basically was told it was my fault, and they will not move forward with the situation. So Adam, what is your advice if someone is dealing with an issue like this where maybe they let a valet attendant park their car and there was damage?
Right. So this can be a little bit of a tough one, and it's kind of a question near and dear to my heart. I'm a little bit of a car guy. I try to take good care of my cars, as we all do. I mean, they're expensive these days, and your automobile is a big investment. So the first thing that really comes to mind here is you've got to understand the interplay of what's going on here. So you've got the hotel or the restaurant that you're valeting your car at, but oftentimes what you might not realize is that they are using a third-party company to actually handle those valet services. And where you might find information about that, believe it or not, when you give them your keys, you get this little ticket back. And you look on the back of that ticket, and often that ticket is going to maybe explain who the actual valet company is, because that may be where you want to submit your claim, not the hotel or the restaurant. And two, I think another thing that's important to realize is there may be disclaimers of liability on the back of that ticket. And so that's something to keep in mind as well. So that would be step one. If you still have that stub, or if you're valeting your car in the future, make sure and maybe hold on to that ticket, because that may have some information that will help you. The second thing that kind of pops into my mind when I'm thinking about this situation would be just the realities of proving who did the damage. So one, I would want to know, did the caller see the valet actually damage the car or not? Was it actually witnessed, or was it a situation where you're done with dinner, you're leaving the hotel, they bring the car around and you see that it's scratched up? So based on the details here where it says the valet ran over the curb, I'm thinking maybe the consumer actually witnessed it, which that's good. Because otherwise, how are you got to ask yourself, in a court of law, in a civil case, you as the consumer, you have the burden of proof. You have to prove to the judge or the jury that it's more likely that this wrongdoer is the one that damaged your car. And when you leave this thing with a valet company, you don't know. The person parked next to you may have opened the door into your car. Something else may have happened. So it's really critical what you can document and prove. To that end, I think some other tips, I would say, number one, look at your car before you leave. If you valet your car and you're worried about this kind of thing, do a walkthrough, right then and there. Take a walk around the car. If you see anything that's amiss, I think you're going to have much more success getting the valet company or the hotel or restaurant to address that problem if you talk to them right then and there, rather than if you go home, you notice it later, now you're calling, and I think that makes it a lot easier for them to blow you off.
All right.
Yeah.
Some good advice there, Adam. I didn't mean to cut you off. Did you have something else you want to add?
Well, just, you always, I guess, have the option of going through your own insurance. So if you've really
Right.
tried everything, you've hit a dead end with the restaurant, you've hit a dead end with the valet company, you could put in a claim with your own insurance company. But of course, the downside to that is we all have deductibles. And so now all of a sudden, if you make a claim with your own insurance company, you're having to come out of pocket $500, maybe $1,000 for damage that you didn't cause.
Some great advice, Adam. Thank you once again. Remember, you can ask your questions as well. If you have anything that you're wondering about right now, we will try to answer your questions as best as we can. Remember, you can always email me at askanthony@firstcoastnews.com. All right, Andy, let's pull up this next question from Joseph. This is the email he sent me. He said, I need your assistance in getting a refund from Verbo for my honeymoon rental at Tybee Island that I actually never stayed in because I could not access the property. This has been an ongoing dispute since they debited my account on December 1st, 2024. And Joseph told me some more. He wrote in that email. He said that they did acknowledge that he was not able to actually use that rental, but he has yet to receive a refund. What can he do in this situation, Adam?
Wow. So first off, my heart goes out to you. That's not a great way to start a honeymoon. That's tough. So when you're dealing with Verbos, Airbnb, and similar services, again, this is a little bit like the first question. You've got to understand who's actually the responsible party and who you actually have the contract with. So believe it or not, even though you're the consumer, you're logging onto the Verbo website, you think you're doing business with Verbo, your rental agreement is actually with that property management company or with that property owner. It's not with Verbo. So they are sort of the facilitator who collects money, distributes it between the parties, but you don't actually have a contract with Verbo. And so this is a little comfort to someone that had their honeymoon ruined. But if you look closely in that fine print on the Verbo website, you're going to sort of see that if you have a dispute with that property owner, that's between you and them. And Verbo has expressly said, we're not going to get in the middle of it. So number one, make sure you're actually complaining to the right person. Yeah, Joseph, if you've been reaching out to Verbo, you're running into dead ends, maybe try something a little different. Look in your original documents in your rental agreement and see if, hey, maybe you need to make phone calls or send emails to a different party. Another thing that I can recommend, and this sort of goes without saying, is really do your due diligence before you do one of these Airbnbs or Verbos. You need to check the reviews online, research how long that property has been rented out, do a little research on the owner or the management company, see what those reviews look like, check Better Business Bureau, and those are all things that can kind of protect you on the front end. One other tip here that really may help folks that I think you might not consider all the time, if you have booked a trip like this with your credit card, so specifically a credit card, not a debit card, and you don't receive the goods or services that you actually paid the vendor to receive, you do have rights under something called the Card Act. It's a federal law, okay? And it protects consumers and limits their liability if those goods aren't delivered. So that is something to look into, maybe disputing this charge with your credit card company and going through that process and see if you can get relief there rather than through Verbo or through the property owner.
Adam, let's talk about landlord-tenant disputes. This is something I deal with often, and I'm sure that you do as well at Jack's Legal Aid. I received this email from Amanda. She said, a landlord won't let me break my lease. I think they're trying to squeeze every penny possible, and if they did let me, it would be admitting they failed to maintain a safe living environment. She didn't give me a lot of details when I replied to her email, but that's a question that she has. So let's just talk a little bit about that. When you're a tenant and you're trying to break a lease, what rights are you entitled to, and maybe what rights is your landlord entitled to?
Right. So first and foremost, we got to understand that a lease contract is a contract like any other. And there's a lot of misinformation around, oh, I've got 3 days after I sign a contract, there's a cooling off period, I can change my mind. And that is not generally the case with the vast majority of contracts. So once you sign, you are bound for that entire lease term, unless there's an exception. So what we would be looking for here in Amanda's situation is whether an exception applies. And we can tell by her email, she's saying that there's not a safe living environment. So the good news is that under Florida's landlord-tenant law, this may give Amanda or someone else that's in her situation a way to get out of their lease. So there's a provision in Chapter 83, which is Florida's residential landlord-tenant code, and that says that if your landlord is not maintaining the property up to code, up to Florida statutes, or is in material violation of your lease, you as the tenant may have the right to terminate that lease after you give written notice. So there's two big things I want to make sure I'm highlighting there. One, the violation by the landlord must be material, and it must actually be a breach of the lease or the laws relating to habitability. It can't be some really minor thing. There's a scuff on the floor or just a discoloration on the ceiling. We're generally talking about things like a leaking roof, the floor is caving in, there's sewage coming up through the bathtub. And these are all real examples of things I've seen. So if you have something really serious like that, you can put your landlord on written notice and say, hey, I'm paying you rent. I need you to fix these things. If you don't fix them, I'm going to terminate my lease. Other ways that you might be able to terminate your lease early, so that's one exception, conditions. Another would be if you're a service member, and there's a lot of those here in Jacksonville. We've got a lot of Navy members. So if you are a service member and you get a different deployment, let's say, and you need to move, or you get discharged from the military and you need to break your lease, you are allowed to do that under Florida law. And then the third way that I can think of that comes up somewhat often is if you're a person with a disability. So there's a federal law, it's called the Fair Housing Act, and it protects you from discrimination. And if you're a person with a disability, it allows you to do something called a reasonable accommodation. So let's say you become disabled, and that disability is permanent, and you can no longer use or enjoy that dwelling that you're renting. You can't get up the stairs, let's say. It's not accessible by wheelchair. You could use that Fair Housing Act to request a reasonable accommodation to get out of that lease. But generally speaking, you're stuck in there unless you pay a penalty.
Right. All right, Adam, let's talk about gift cards now. This is an issue that I wish I could help many people with who are having disputes with gift card companies. This email came from James. It says, on March 31st of 2024, I sent a $500 gift card on Hotels.com to my daughter through Amazon. The gift card was sent to her via email, but she was not able to use it at that time. She later inadvertently deleted the email, which could not be recovered by Google, as it was more than 30 days before she noticed. I have tried repeatedly to have Amazon either reissue the gift card or reimburse me as the sender. Amazon claims that their policy with third-party gift card service is limited to 30 days and therefore can't reissue. I've asked for a refund to my account and have been told that they won't. Is there anything that James can do in this situation?
Well, James, I feel for you, but I'm glad you sent in this question because I really think we may sort of be hitting a theme here, Anthony, which is that when you're doing business with any company, in particular when it's online, you don't always know who you're transacting business with. And so what Amazon is essentially saying here is even though you purchased this good or service using my web platform, you actually purchased it from a third-party company. And because this isn't an Amazon branded gift card, we can't help you get that refund. And that's actually true. So I did a little bit of research on this, particularly with Hotels.com, and you'll see a disclaimer if you pull it up on the website. This card's not issued by Amazon. It's actually, in fact, not even issued by Hotels.com. Here's this third-party company, and it says in that print, if you lose this card, if it's lost, damaged, destroyed, we are not responsible and we are not replacing it. And so even though I really feel for this consumer, it's a good reminder that even with digital transactions or emails, which a lot of things are moving towards, we're signing contracts with DocuSign, we're having, cryptocurrency, digital currencies, and you have to consider this email. It's almost like cash, okay? It's like anything else. And so in the same token, if you've accidentally deleted this email, if you've accidentally lost it, I don't know that Amazon has a responsibility to help you. It'd be just like if you dropped it in the street and couldn't find it anymore. But again, let's talk some proactive tips instead of doom and gloom. One, again, if you purchased it with a credit card, you may have some protections there, so you may want to try disputing it, although I don't know that it would necessarily work in this scenario. So that's probably the route I would go. You may try to reach out directly to Hotels.com, especially if you've been a past customer. Maybe they're willing to kind of help you out. So those are two things that I might recommend. But just for all the viewers out there, want to take an opportunity. Gift card scams, and this doesn't seem like it's a gift card scam, this was a gift, are becoming more and more common. So especially our senior citizens, they may get a phone call and the scammer is going to try to entice you to send them payment with gift cards. You absolutely should not do that. You should not send anyone that you don't know money, gift cards, or any other forms of payment over the phone like that. So that's just kind of a hot tip of an issue we see at our law firm.
All right, Adam, thank you. Don, I see your question. Right now, I am going to ask Adam that question in just a minute, but I want to go ahead and get to this issue from Karen. She sent me an email this week. It says, the neighbor behind my brother's house, they have 2 American pit bulls. Last week, they dug under his fence and killed my brother's beloved dog. There is a case with animal control. However, to date, nothing has been done. We would like the dogs to be removed or at least be classified as a dangerous dog. This is something that I deal with often. I receive a lot of emails about issues when it comes to dangerous dogs in neighborhoods. What can be done, Adam?
Yeah, this is really a heartbreaking situation. I'm a dog lover. I've owned dogs my whole life, so my heart really goes out to Karen. So here's kind of what I think are the important takeaways here. Number one, you sort of have to let the process play out a little bit. So there's a specific Florida law on dangerous dogs. That's Florida Statute 767. And part of that process involves animal control actually having an investigation, taking a formal complaint that there's been a dog bite or an incident, and then the dog owner does have the opportunity to go to that hearing, contest the findings, sort of have their day in court. But it's not really an official court proceeding, it's an administrative proceeding. So number one, you're going to have a little patience. What this dangerous dog statute essentially says is there's 3 ways that this can be classified. One, if this dog attacks a person who's either in public or on their own property. So if they bite a person or attacking a person, 1 strike, dog's out, okay? The second way is if that dog kills another domestic animal. And that would actually be the situation we're dealing with here. If a dog seriously injures or kills a domestic animal, on the other hand, it is not a 1-strike situation. It actually has to be more than once. And so if Karen is looking to have this dog deemed dangerous, we would have to know, is there any prior history of this dog attacking another domestic animal? And then the third way, not applicable here, but if a dog, again, is chasing or menacing, following someone around on public property, that's another way a dog could be deemed dangerous. So That's kind of the legal background. There is a way online, so you can go right online to jacksonville.gov, and you can fill out the affidavit to request that animal control deem this dog dangerous and conduct this type of investigation. So if that hasn't been done yet, I would encourage Karen to go online and make that complaint. You know, the other thing, as much as it kind of pains me to say, is Florida law treats animals, personal pets, even though we might have a great emotional connection to them, it treats them as personal property. And so generally speaking, you're not entitled to any sort of special damages, emotional distress, punitive damages, those sorts of things. It's basically the value of the dog if your dog is killed. And that can be really hard for a lot of people because they feel like, well, this was a family member, a friend, right? My kids have grown up with this animal, and they want more compensation. And just generally speaking, that's not in the cards, even if the dog owner was negligent.
Adam, going back to the landlord-tenant dispute that we were talking about earlier, Dawn just left a comment. It seems like she's having an issue with the housing authority in her area. She's talking about floors are broken and already caused me to fall 7 years ago. Lights out, dumpster problems. Lise says no stray animal feeding, and many here do that. Everyone is either disabled, elderly. Roaches are everywhere. This seems to be an issue she's having with her apartment complex. So for Dawn, who's asking this question now, just once again, when people are in a situation like this at an apartment complex, what should they do?
Yes. So assuming that this comment is accurate, if this is the Jacksonville Housing Authority.
It doesn't appear to be the Jacksonville. I think she wrote Tampa Housing Authority.
Okay, well, Tampa Housing Authority. So it is a little bit different. So when you're dealing with the housing authority, oftentimes instead of calling municipal code compliance, going to the Hillsborough County Code Compliance or Tampa Code Compliance, you have to go to the housing authority itself to have them inspect. And so this can be a little bit confusing because, well, they're in charge of inspecting their own properties, and I've already lodged these complaints and they're not doing anything. So you can be in a little bit of a tough position because often the municipality won't come out and inspect public housing. So one tip I would say is there's usually a regional HUD office. So there's a regional office that is over housing authorities and public housing within that region. Make a complaint to them. Go over that property manager's head, lodge that complaint with the regional authorities, and maybe they can actually get someone down here to take action. Number two, and I'm sure, Anthony, you've seen this locally, there's been great success here in Jacksonville when there's been big problems by going to your council members. Write your senators, write your city council members. We've had big problems getting conditions fixed at subsidized housing. But, if Marco Rubio shows up or your city council member shows up and starts demanding answers, oftentimes things get done. So that's another tactic you could try.
All right, Adam, I have one more question if we can. We got about 2 minutes left. This is from Luann. She says, I was overcharged on material costs for a deck project on my home. I have contacted the contractor and he refuses to rectify the situation. I have already paid him in full. Is there anything I can do about it? If you can quickly answer that question for us.
Absolutely. So step one here is a complaint to the Department of Business and Professional Regulation. And the reason I feel that is so important is they are the ones that actually control the contractor license. And you get the contractor's attention that way. So if you haven't already, Luann, do a DBPR complaint. You can just search for that in Google, DBPR complaint form. You can do it online. You can print the form or mail it in. So I would start there. If that doesn't work, send a letter. Excuse me. So you have a paper trail. That's a lot better than a phone call. And unfortunately, your last resort, if those things don't work, is you can't force them to pay you without going to small claims. And small claims can take time, cost money, oftentimes can be frustrating. So that's truly a last resort. So start with DBPR and hopefully that solves the problem.
All right, some good advice once again from Adam Thoresen with Jack's Legal Aid. Adam, we thank you for being here today. And remember, if you have a problem that you just can't solve, you can always email me at askanthony@firstcoastnews.com.